Good afternoon, everyone. My name is Lindy Kutsia. I'm from the Faculty of Law, and I have the privilege of being the program director for this afternoon. This afternoon's project is a partnership between the Faculty of Law and the Chair for Critical Studies in Higher Education and Transformation and the Herald, the public lecture. The lecture will be delivered by nobody other than Advocate Tembeka I practiced this. Ngcukaitobi. I think the majority of us know the author of The Land is Ours. He's a well-known advocate. He was involved recently in the litigation around the Zim elections. So I think for the lawyers among here, we are definitely all in awe. Ladies and gentlemen, but what is the purpose of this public lecture? The purpose of the public lecture is Mandela as a lawyer. And we are celebrating the centenary of the birth of old President, the late President Nelson Mandela. And this is the start of a series looking at President Mandela's role as a lawyer in society. And I really think it's critical discussions that we need to have. And on that note, I, at this point, want to welcome, and I know everybody is important that is here, so I'm going to deal with, you know, how people get away with it. They say all protocols observed. But I won't be me if I don't just welcome one special group. Ladies and gentlemen, if I can just say, welcome to the final year law students. I know everybody else is very important, but I also know that, you know what, there are so many demands on these students preparing before their finals currently, and they are always available when the faculty has an event. So guys from the Faculty of Law, great appreciation from our side to show that you take law studies more serious than just simply submitting assignments and doing tests. Now, ladies and gentlemen, I'm not going to waste a lot of time. You will see that we have a program and we have a speaker, and you've listened, well, the majority of you have listened to me long enough and don't want to anymore. It gives me great privilege to ask my colleague, Professor Chivasi, who will be introducing our speaker, Prof. Chivasi, from our Criminal and Procedural Law Department, the head of department there, who will be responsible for introducing our speaker for this afternoon. Thanks, Prof. Chivasi.
Okay, thank you, Program Director. You know, that's what happens when you are not a logistics person and then you try and fiddle with logistics. Okay, thanks again, Program Director, for the opportunity for me to introduce our speaker this afternoon. Esteemed guests and dignitaries from all walks of life, members of the media present here, colleagues and students, ladies and gentlemen. I'm going to be doing the most interesting introduction of a speaker for me, and perhaps also a challenging introduction for two reasons. The first one is that, perhaps let me say the most interesting reason is that Advocate Ngcukaitobi, hereafter sometimes referred to as Tembeka, is a personal friend of mine of many years. So that is the most interesting part of this introduction. And on that lighter note, today it is my turn to embarrass and tease him a little bit, because he was doing the same to me from the very same podium when he was launching his book in May this year. Those of you who were here will remember what I'm talking about. So this is my turn now. Tembeka and I were close colleagues at the Constitutional Court 17 years ago. And yeah, it sounds like a very long time ago. Eh? He was a researcher to the then Chief Justice Charles Carlson, and I was working for Justice Kate O'Regan. During lunchtime, we would go for pap and braai vleis at a place called Mzito's in Joburg. Do you remember that, Tembeka? And in fact, as we were being served some sandwiches there, he was telling me, Chivasa, this is not your food. I know you like pap and braai vleis. Then I was just, deep inside me, I was laughing because I was going to be talking about pap and braai vleis that we used to enjoy in Joburg. So now, what is challenging about this introduction is that Advocate Ngcukaitobi requires no introduction to many people. Why do I say this? He requires no introduction because he's seriously famous for a number of things. I could actually go and sit down now and let him deliver the lecture, but there's more to be said. Advocate Ngcukaitobi is a celebrated lawyer, a public commentator, and a groundbreaking author. He has virtually appeared before all superior courts in the Republic of South Africa, including the Constitutional Court and the Supreme Court of Appeal. He has litigated in the state of capture cases, among other notable cases. More recently, he was involved in the Zimbabwean election case across the border, which was widely reported in the media. In fact, as we were coming from the airport, he was telling me that he was invited at VETS yesterday to talk about what happened there with regards to that case. He has also served as an acting judge in the Land Claims Court and also the Labor Court. Perhaps most notably, as I hinted earlier, he has written a groundbreaking book entitled The Land is Ours, South Africa's First Black Lawyers and the Birth of Constitutionalism, which is currently being read on SAFM, for those of you who may not be aware. Oh, for those of you who don't listen to radio. Through this book, he has redefined aspects of the history of South Africa and has also shaped the land debate. He's also a member of the 10-member panel recently appointed by President Ramaphosa to advise on the land question. And in fact, I was asking him about that appointment as to what is this about. He said he's unsure. Everyone is not sure really exactly what we are going to be doing on that panel. Importantly for this lecture, Advocate Ngcukaitobi is also someone deeply interested in thinking about Mandela as a lawyer. We've had lengthy discussions about this, Mandela as a lawyer, and I'm glad to see that this has culminated into something like this. So he's deeply interested in the subject. So, ladies and gentlemen, there is certainly no doubt that Advocate Ngcukaitobi is the perfect lawyer to deliver this public lecture. And finally, I am absolutely thrilled and proud to announce that Nelson Mandela University has appointed Advocate Ngcukaitobi as an adjunct professor in the Department of Criminal and Procedural Law in the Faculty of Law. And I should mention that he has accepted the appointment. So, he is now one of us, and we look forward to supporting his work in the next 5 years. So can I take the honors and hand him his letter of appointment as we give him another round of applause? Ladies and gentlemen, it gives me enormous pleasure to introduce one of the most thoughtful and courageous lawyers of the new South Africa, Professor Advocate Tembeka Ngcukaitobi, to deliver a public lecture entitled Mandela as a Lawyer. Ladies and gentlemen, let's welcome Professor Ngcukaitobi.
Thank you. So I should start by opening this envelope so that I can say that what is inside here did not come from VBS Bank. Especially, Enos, you thought that you would have the last laugh. You can't. Especially given Enos's origins. And it is a letter. You see. So for a change, Enos told the truth. So thank you very much. I'm especially privileged, proud, and honored. Not only because I've been invited to speak here, but also because of the subject that I have been asked to talk about, which is the subject of Mandela, the lawyer. Most of you who have encountered with my work and the things I say, the things I write about, will probably know that I am interested in black thought and black intellectual thought of the era of the empire and the black intellectual thought of the era of apartheid. I don't want to understand black lives only as outlaws or people that resisted, but I also want to understand them as people that thought of alternative ways of being, of people that thought that there was a possibility for a new world order, even in the context of the sort of aggression of colonialism, even in the context of the aggression of apartheid. So Mandela fits this kind of intellectual project that I've been interested in trying to find out what was life like for lawyers of the 19th century, lawyers of the 20th century, and lawyers of the early 21st century. So and I'm trying to package these lives and to try and illuminate them and make us understand about what the experiences might have been like. And yes, people take whatever they want to take from my book. Others take the land issue, and others take the constitutionalism issue, and others take the histories. But I prefer the histories of the people, the sort of histories of the resilience of the soul of the people that lived under the era of colonialism and what they thought of their world. So Mandela fits in the 40s and in the 1950s, right at the time when the last lawyer that I speak about, Pixlika Isakaseme, who dies in the 50s, 1951. And it's precisely the point at which Mandela becomes the lawyer. In a sense, you can see the passing of the baton from the old guard to the new guard. And I am trying to investigate his life and to try and understand what that period must have been like. And the period is a short period. It is the period between 1952 and 1962. It is a 10-year period, but it's a relatively short period in historical terms. And one of the reasons why this is an interesting area of inquiry to me is not only to look at Mandela as someone who thought that there was an alternative way to apartheid, but also because this area of Mandela's life is completely under-researched. We know a lot about Mandela the revolutionary, Mandela the person who started MK, Mandela the person who went to prison, and Mandela the person who gave the famous Rivonia trial speech. But we know very little about what it must have been like to be in court with Mandela, what it must have been like to be Mandela's client, and what it must have been like to listen to Mandela arguing a case in court, and what impact his own experiences as a lawyer had in the shaping of the man that he subsequently became. And his life, in many respects, is some kind of a paradox, because on the one hand, we encounter Mandela, the lawyer, but in that same vein, we encounter Mandela, the outlaw. At the same time, we encounter Mandela, the constitutionalist, but in the same person, we see Mandela, the revolutionary. And so I try not to make the sort of dismissive, generalized perceptions. You either love Mandela or you don't like him. If you don't like him, he's a sellout. If you love him, he's a saint. But I try to say, let's get a scientific basis from which to proceed in understanding Mandela. So first, the question of the context. What was the context in which Mandela operated? So as I say, we start thinking of Mandela, the lawyer, in the late 1930s. And this is the time when Mandela arrives at Fort Hare. At that point, he has studied in the two Eastern Cape universities, Hilltown as well as Clarkbury. And he has qualified in those universities, and he's thinking about what he should do when he's at Fort Hare. At Fort Hare, he registered for a BA degree. One of the problems with this kind of research is that it's been extremely difficult to piece together his actual university transcripts when he was at Fort Hare, either as a result of the fact that maybe they don't exist. There are people who actually say Mandela's records at Fort Hare don't actually exist, or because they have not been kept. In other words, they might be somewhere we have not been able to find them. But when he arrives at Fort Hare, he decides to study a general BA, but he specializes in anthropology as well as Roman Dutch. At the time, I think it was called Roman Dutch law or Roman law. So it's got these two subjects. But at that point, Mandela does not want to be a lawyer. He has not yet decided that he will be a lawyer. What he wants to be a civil servant. And specifically, he wants to be an interpreter. And that was what he wanted to do at Fort Hare. And he explains this in his autobiography, that the reason I wanted to be an interpreter is because I wanted to help my mother. So what we see from Mandela is that we don't get him as sort of a global figure or as a national figure. We get someone who is purely concerned about helping his family. Because, as we know the history of Mandela, his father died whilst he was quite young. And it was his mother, Noseken, who then looked after him and was responsible for his upbringing. So when he went to Fort Hare, his intention was to get a qualification that would enable him to join the civil service in order to look after his mother. At Fort Hare, Mandela had encounters with two other people. If we forget for a moment the encounter with Oliver Tambo, because it becomes relevant to Mandela's life quite later, the encounter with two other names that are actually obscured in Mandela's life, George Matanzima and Kaiser Matanzima. And who were they? These were Mandela's brothers. In Xhosa, they would be his brothers. In English, they would be his cousins, right? So, because, Xhosa was like, we're all together in this thing. And the English, I'm like, okay, I'm an individual. Yeah. All right. No, that's not what I mean. But can I say something? Last time I came here and I spoke about my book and whatever, and then I saw some people leaving, okay, so today I've decided I'm going to be inclusive, okay? And Mandela provides us with a canvas for this inclusivity, So, because, with Mandela's life, you can write anything. It's like a blank canvas. Just put anything you like there, You can put reconciliation and put revolution at the same time, So he is that kind of a figure. So back to Fort Hare. Two names that are crucial and obscured in Mandela's upbringing, Kaiser Matanzima and George Matanzima. And who was Kaiser Matanzima? And Kaiser Matanzima was Mandela's cousin. They both came from the sort of aristocratic background and of princes of the Tambo family, or the families of the Aba Tambo. Kaiser had already decided that he was going to be a lawyer. And Kaiser was almost about to finish his studies. And it is Kaiser who first planted the idea in Mandela's head that he should study law. But even then, Mandela was dismissive about the idea of studying law, even when Kaiser suggested it. We know what subsequently happened to Kaiser is that after he qualified and he finished his BA degree, he went back to the Transkei, where he sat for his, firstly became an article clerk, he sat for his attorney's admission exams. And both him and his brother, Kaiser and George, were actually very, very talented students. Kaiser, in fact, I think obtained the highest prize, not native or anything, but the highest prize in the Eastern Cape examinations for, at the time, article clerks, right? So across all races, Kaiser Matanzima, in that year when he sat for it, became the highest student. The same with his brother, a younger brother, George Matanzima. For his JC exams, he was the best student and winning the Cape Prize for the JC examinations. And this is late 30s, early 40s. So this is the background at Forte of Mandela's encounter with the idea that I would like to be a lawyer at some stage. But even then, Mandela is still not convinced about this prospect of being a lawyer. What then happens, the principal at Forte at the time was a fellow called Alexander Kerr. Mandela was elected to the SRC. This is now 1940. He's elected to the SRC. He says that in his biography, because the students that had elected him somehow did not support the SRC that was elected, because only a few students participated in the election results, he then decided that he would not continue serving in the SRC. And he was then summoned to the office of Dr. Kerr in order to explain why he would not assume or take the position in the SRC. Dr. Kerr refused to let Mandela not serve in the SRC. And that disagreement led to Mandela leaving Forte. He was then effectively expelled from Forte, but he was then told that he could come back the following year, which is 1941. But what we know then is that Mandela, together with his other cousin, a fellow called Justice, decided effectively to leave the Transkei to Johannesburg. The explanation that is given is a very complicated explanation because it looks like what had happened is that Justice's father, I think a fellow called Pondombin, Justice's father wanted Justice to marry a particular woman that he had chosen for him. And together with Mandela, they then decided that they would leave the Transkei and go to Johannesburg, initially looking for a job in the mines. And even at this stage, Mandela had decided that he would not be a lawyer, but he just wanted a different lifestyle. And that is how he left the Eastern Cape to arrive in Johannesburg. There is complication around the story. An author who has researched the story and wrote the book, Young Mandela, says that it is almost impossible to verify that this, in fact, was the reason why Mandela left and why Mandela didn't come back to Forte. And if you add the fact that we are finding it extremely difficult to get Mandela's, in a sense, student records at Forte, it leads to this gray area in piecing together Mandela's life. Nevertheless, what is uncertain is that by 1941, Mandela was at Johannesburg. This then is the beginning, really, of Mandela's shaping and thinking about becoming a lawyer. But what was going on in 1941 in Johannesburg? At that point, the Afrikaner aristocratic thinking was emerging. It was getting stronger and stronger, although there was still a contestation because the National Party was not yet in government. But the world that he encountered was a world that was increasingly becoming racist, a world that was increasingly becoming entrenched in the ideology of Afrikanerdom. And black people and exclusion was getting entrenched in that period when Mandela arrives in Johannesburg. And who did he meet? One of the people that he met was Walter Sisulu. Walter Sisulu was one of the few black people that was dealing with property. He ran an estate agency. He could acquire and sell property in one of the few areas in Johannesburg at the time that allowed black people to own title. One of those areas was Sophiatown. And Walter Sisulu was a relatively successful businessman. And as part and parcel of his practice of a property agent, Walter Sisulu had established relationships with many, many attorneys, especially conveyancers. And it was through that relationship that Mandela was then introduced to a firm of attorneys and conveyancers. And his principal that he encountered was a fellow called Lazar Sidelski. But we go back to Mandela's education. How did he acquire his BA? And how did he acquire his LLB? Of course, many of you are familiar with the story of Mandela as a student at Fort Hare University. Well, the truth is that Mandela actually never graduated at Fort Hare. Did he graduate at all? Yes, he did. But at UNISA, via correspondence. Unfortunately, UNISA is not mentioned that much in Mandela's life. But there are a few things I think you might be interested in Mandela as a student, since some of you are students and some of you are final years. The first one is this very interesting document here. I wonder if I can't. I'm trying to expand the thing so that you can see for yourselves that you are not the only ones. Anyway, it looks like I can't expand this. So this year is 1943, right? Mandela has already acquired his BA, but he has decided that he will now register for his LLB. In those years, it was not necessary to acquire an LLB in order to be signed up for articles of clerkship. You could sign up for articles of clerkship pretty much with your BA. Another good example was Oliver Tambo that Mandela also met in Johannesburg. Oliver Tambo had a BSc degree, specializing in mathematics and in physics. And he had worked as a candidate attorney or an article clerk at a firm called Rich Tenor. So this is Mandela's bachelor's results. Look at 1943, that very first year. Roman Law 1 fail, Roman Law 2 fail, Constitutional Law fail, Introduction to the Study of Law, Legal Latin fail. Percentage 36, 41, 43, 30, 40. I knew that would interest many people. And then we see in 1944, he sort of tries 4 passes, 1 fail. That's good enough. 1945, 2 passes, 3 fails. And then 1946, 4 passes, 1 fail. And 1947, 6 fails. Now, this is all happening at Wits University, where he has registered for his LLB. There is a picture, I was not able to upload it, but there is a picture of the Wits Law faculty. It shows about 8 LLB students, and Mandela is in the middle as the only black student. He says in his autobiography that he thought he would be the first black person to be admitted as an advocate in Johannesburg. As you know, in my book, I have shown actually that he was mistaken, because even as he was writing, there were already 4 black advocates that had been admitted way before him. But also even in his own group, his friend Dumanokwe subsequently became the first African advocate to be admitted in Johannesburg. So if we then, yes. So in 47, we have seen the kind of academic struggles that he was encountering. So what he then did in 48, because there was a problem about whether he would be allowed to sit for a supplementary exam, because as you can see, he clearly didn't qualify. And this is an extract from a letter that he wrote to the university, applying to justify why he should be allowed to sit for a supplementary exam, because he had already spent essentially 4 years trying to pass a degree that you should ordinarily pass in 2 years, and really struggling to pass this degree. And then he says, I can't afford. At that point in time, he had become married, and he had already 2 children, and he was struggling to make ends meet. But look at what he says as the explanation. Those of you who were laughing a lot can now read his explanation. I should also add that during the whole period, I studied under very difficult and trying conditions. I was a part-time student and resided, as I still do, at Orlando native location in a noisy neighborhood. In the absence of electric light, I was compelled to study in the evenings with a paraffin lamp and sometimes with candlelight. I wasted a lot of time traveling between Orlando and the city and returned home after 8 p.m. feeling tired and hungry and unfit to concentrate on my studies. Even during the examinations, I was compelled to work in order to maintain the only source of livelihood that I had. It is my candid opinion that if I could have had done my work under more suitable conditions, I could have produced better results. No one studies today with a paraffin lamp, a candlelight, traveling between Orlando and the city, arriving home at 8 p.m. But I have no doubt all of you believe that if your conditions were better, you would produce better results. And so this is the outcome of that application he made to be allowed to sit for a supplementary result. And look at the decisions that are made. This is now at the faculty board. Weber is allowed to sit for the special examination. Sutage is allowed to sit and is in fact exempted. And look at Mandela. It was agreed that in view of the regulation of the board, regretted that it could not accede to the request of Mr. Mandela, who had failed in 3 courses in the final year. We know that he failed 5 courses. In the November examinations to write supplementary examinations. This letter effectively marked the end of Mandela's attempts to obtain his LLB via Wits University. If you go there today, there is something called the Nelson Mandela School of Law. Yes. Then I will come back to the time at when he was at, this is now at Robben Island. We have to finish his Mandela's struggles to become a lawyer, and I'll make my point later. We know that in 1961, Mandela went through 3 trials, right? But we know that the last trial was the Rivonia trial, and that he was arrested, sent to trial, and ultimately found guilty. 1963, a sentence is passed. In 1964, he begins his sentence at Robben Island. And in 1966, he was writing to the University of South Africa in order to be allowed to continue his LLB degree. And this is a letter that he wrote on the 29th of April, 1966, to the University of South Africa. He was not allowed to sit for this. The university refused. Later on, this is in 1974, 8 years after Mandela, 10 years after he was sent to Robben Island. And he writes to the University of Wits on the 18th of November, 1974. And he is now appealing to the university to allow him to continue his LLB degree. But the university writes back to him, saying that we cannot allow you until you get a special dispensation from the minister. And what we know about this is that after the Bantu Education Act and the Extension of Universities Act, black students were not allowed in white universities. So those of you who don't understand, this used to be a white university, okay? And blacks were not allowed here. Now I see this hall. I'm like, what's going on? So in universities like this, black people were not allowed. In some universities, you could go in, but provided you got a special permission from the minister. And the university here is telling Mandela that because you don't have a special permission from the minister, you are not allowed to register for your LLB. But you can see the quandary. Mandela is locked up by the minister. But in order to study, he must obtain permission from the minister. And then in 1981, and this is a letter that comes in 82. In 1981, this is now many years after the 1974 rejection, he writes back to UNISA. Fortunately, at this time, UNISA had a different dean of law who then spoke directly to the government. And he said to them, guys, it no longer makes sense to prevent Mandela from studying for his LLB degree. I will make sure that he studies and I'll make sure that he obtains. And again, this intervention of UNISA in Mandela's life is something that is not spoken about in the historiography of Mandela. So we see here where he is now being allowed to register again at UNISA to continue his LLB studies. And that's 82, and that's another letter from 1982. And these are his results in 1986. You see, things are changing here. 5 subjects, passed, failed, passed, passed, passed. You know. The prison conditions were clearly conducive to Mandela. to Mandela the student, unlike the Orlando conditions. And in 1987, there is a dispute about a curriculum, but he is now left with only one course. And he finalizes that course in 1988. So, how many years? 46 years it took Mandela to obtain his LLB degree. Which considering that 27 of those were spent in prison, is still an amazing achievement. But it also tells us something about Mandela and this resilience of the man, and the fact that he was not prepared to allow those conditions in prison to prevent him from obtaining his dream of being Mandela BA LLB. In 1989, of course, the political climate in South Africa had changed. The National Party had decided that the future for South Africa is going to be a negotiated future. And so it's possible to put context into the decision by UNISA to allow him to continue, and into the decision by UNISA ultimately to allow him to graduate. But the point is that this is a man who was prepared to sit and wait his turn, and to sit through the struggles of both prison and the struggles of Orlando. I don't know how many of you would be able to complete a degree, or at least to keep a dream alive for more than 5 years. Mandela could keep one dream alive for 46 years. We must then go back to Mandela's life as a lawyer, now that we've seen his struggles as a student and how he managed. And this takes us back to the 50s. This is the firm, Lazar Sidelsky, that took Mandela on as an articled clerk. And the work he did with this firm was wills, properties, and low-level magistrates' courts. Once he finished his articles, he went to work for another firm called Teblanche and Briggish, and then joined this firm called Hellman and Michel. But if you look at his explanation about the two firms, in the first firm, Sidelsky, his work was primarily estates. His work was also including low-level magistrates' court work. He recalls an encounter with Sidelsky, who told him in clear terms that he should not involve himself with politics, because politics and law do not go together. Okay, now, is there something I touched or? Okay, good. Yeah, well. And then later on, Mandela is admitted to a firm called H.M. Basner, which would be a very important firm. Jesus. All right. Okay. So we are still in 51 and 52, and we encounter a fellow called H.M. Basner, who was a communist and a liberal at the same time. But Basner was a representative, a native representative in the Cape. And this is important, what these native representatives were. So in the 50s, black people did not have direct representation, even those that were still able to vote. They did not have direct representation in parliament. Their representation had to be via white people. Those of you who don't know, Cecil John Rhodes was once a native representative, voted by, guess who? Native people. By this time, Basner, who was an attorney in Johannesburg, was also a parliamentarian. And Mandela worked with Basner. Basner was crucial in shaping Mandela's understanding of the law and the potential that the law could play in society, because his work primarily was political in nature. And we see this in Basner's biography and in Mandela's biography. And Mandela says, "For the months that I worked there, I was often in court representing the firm's many African clients, as long as I got my work done, and at the firm he encouraged my political work." So it is this fellow, Hyman Basner, who shapes Mandela's thinking of the law and who disabuses Mandela's understanding of the law as something in opposition to politics, and actually says there is a synergy between the two. I have drawn here this contrast between Sidelsky and Basner. Sort of Sidelsky as the traditional lawyer, but Basner as the radical lawyer. A radical lawyer who is able to pursue causes that he believes in and does not see the distinction between being a lawyer and at the same time pursuing political causes. And this part is basically Basner campaigning, and this is not particularly important. And this is what Oliver Tambo says. So what had happened here before we go to Tambo? Oliver Tambo had done his articles. He had finished doing his articles, and Mandela had finished and had qualified as an attorney in 1952. Mandela went to open a firm, and both of them were in Johannesburg, opposite the Magistrate's Court. I think it was in Fox Street. Mandela opened this firm, but he then spoke to Oliver Tambo about the possibility of a partnership between the two of them. At the time, in that particular space, there would be the only African law firm, not the first, but it would be the only one operating in Johannesburg at the time. And Oliver Tambo had asked Nelson Mandela for a period of 7 months whilst he was wrapping up his own practice before he could resign and join Mandela in the opening of the firm. And so Oliver Tambo's justification about why, okay, did you lift it or? Okay, yeah, it looks like you just lifted like that. Yeah, okay. So this is Oliver Tambo's justification. As technically proficient as white attorneys might be, black clients were severely hampered in communicating their difficulties to them. Language was a barrier, even when good translators were at hand. If we just stop there and we look at the justification that Oliver gives, which is the idea that even though there are many lawyers in Johannesburg, black people are still struggling to gain access to justice because of the language barrier. Right? I mean, we're in 2018 now, but the language issue still remains a big problem. And then he says, white lawyers' lack of familiarity with African culture, tradition, and values impeded communication, and therefore the cause of justice. And again, it's like this rigid state that believes in race above all ultimately impedes the cause of justice. So from the very beginning, Mandela and Tambo conceive of their firm not just as an instrument or as an institution for the enrichment of the partners of the firm, but ultimately as an instrument for the pursuit of the cause of justice. Removing these obstacles by providing black legal representation might give black people an outside chance in the law courts. Of course, there's a paradox in this because the law courts themselves were extensions, and this is the argument I tried to make last time to the unhappiness of some. But the law courts, if we are to be realistic about them, were simply extensions of the apartheid state. But even though the law courts were extensions of the apartheid state, Oliver Tambo still believed that there was a possibility, no matter how limited, of obtaining justice. All right, so we are now in Mandela in court. What might he have looked like? What was his style? What we know about Mandela, the lawyer, and if you contrasted him with Oliver Tambo, Mandela was flamboyant. Everyone who encountered him as a lawyer remembers his flamboyance, right? But his manner of representation was what I've called didactic. You would sit there and like, my Lord. So his mode of representation was not fluent, although his personality was flamboyant. And so he did not have all of these theoretical flights when presenting a case in court. But if you contrast this with Oliver Tambo, a very close friend of his, right? Oliver Tambo, on the other hand, was more reserved, but he has been described variously as a thinker, somebody who took the law seriously. But on the other hand, Mandela put a lot of stock in his appearance, in his personality. You can see his pictures. And there is a description given by one of Mandela's articled clerks, Godfrey Pitje, who says you could never mistake Mandela when he was in court. Whereas with Oliver, you could actually assume that he was probably just one of the, workers in court. But Mandela's presence was always felt when he was in court because of that flamboyance. Look at what Sampson says, Anthony Sampson, about Mandela's behavior in court. Mandela did not behave as if he were black. Right? Mandela would be walking boldly through the whites-only entrance in a courtroom. So look at this example. So he walks through, it says whites only. He walks through, and then a woman who is white, but who's got a dark complexion, says to him, "This is for whites." And Mandela responds, "Then what are you doing here?" But this description is apt because it illustrates the point I made earlier, that Mandela did not actually carry his race with him. He was sort of always above the racial distinctions. And he had this confidence of when he is present in court, he is here as a lawyer and not here as a black lawyer. Very, very important, especially when everything must fall. Yeah. But we've compared this to Oliver Tambo. I want to say something about Oliver Tambo and the descriptions that have been given about Oliver Tambo. We now know that both of them became partners. The firm was called Mandela and Tambo Attorneys. It was in a building called Chancellor House, opposite the Magistrate's Court. They found it difficult to set up the building and the office in Chancellor House. Why? Because of a little-known act called the Group Areas Act. The Group Areas Act prevented even black professionals from setting up offices in areas that are designated for whites only. So this year we've been talking a lot about land. But the Group Areas Act was almost the final nail in the coffin of dispossession. And we have not spoken about the impact of the Group Areas Act on professionals. It did not discriminate only on the basis of race, but it also meant that people like Mandela and Tambo were simply unable to fulfill their dreams as professionals. So every time, these people who say, I saw an interview yesterday on radio, some woman phones and says, "Are you not embarrassed as a black lawyer that you want the law to help you to rise up?" I'm like, but are you not embarrassed after 350 years of protection by law to be asking me if I'm embarrassed? But the point is that if you look at the impact of the Group Areas Act, it was not just stifling of black progress, it was reversing it. Right? It made it impossible. So think about doctors couldn't practice in the cities, dentists, lawyers. You go on and on and on, teachers, nurses, etc., because they were pushed out of the city. Mandela and Tambo practiced without the requisite permit. They had applied for it, it was not granted, and they set up shop and they continued practicing. But that practice meant that they were constantly on the lookout from when the day the police would come. When the day the police would come with a banning order, the police would come with a notice of eviction. So you have these professionals that are qualified, respected in their communities. But the reality is that it is impossible for them to live out their ability as lawyers. Now, this is a report from the Rand Daily Mail of 1954, showing you the extent of the difficulties placed on Mandela's ability to practice as a lawyer. In 1952, under the leadership of Chief Albert Luthuli, at the time, young men like Sisulu, Mandela, and Tambo, and Mda, and a lot of others, a decision was taken to launch what was called the Defiance Campaign. This is an important part of the history and the shaping of Mandela the lawyer, because this is 4 years after D.F. Malan has won the election of 1948. And Malan won that election under the slogan, apartheid. And apartheid, although later on it was explained by Verwoerd as a policy of good neighborliness, there was no good neighborliness. Apartheid made it clear that there would be subservience on the grounds of race, period. This idea of separate development is nonsense. There was no development by the native people. They were subservient to white people. That is how apartheid was structured. The impact of that among black professionals was felt within the ANC, and a decision was taken that there would be a defiance campaign. Mandela was the chief volunteer in the defiance campaign. Notwithstanding his practice as a lawyer and notwithstanding his commitments to family, but he took the position that he would be volunteer in chief. The result was that by 1953, most of the activists in the defiance campaign were locked up and they were charged with certain violations, especially because you know what they did? They made it an offense to threaten to break a law. Right? Like if you just say, I'm going to defy, that is already an offense, even before you can actually defy. So that is what they were arrested for and charged with. They were then found guilty and sentenced to 2 years, but those sentences were suspended. But what that meant is that they could be banned and could only work within certain defined geographic areas. The Law Society of the Transvaal saw the gap after Mandela's conviction. They brought an application in order to have Mandela struck off the roll of attorneys. Only 2 years after Mandela's practice had begun, the Law Society saw the opportunity to get him struck off. Fortunately, and this is again an important part of the story because it shows that things are not always black and white. The judge that sat in the case, a fellow called Ramsbottom, he dismissed the application. His reasoning is absolutely significant because he says Mandela's participation in political activities should not be confused with acts of dishonesty, because the mere fact that a man pursues political objectives that he believes in good faith to be correct, even if he is pursuing communism, may be a breach of the law, because at the time there was the Suppression of Communism Act, and that is a breach of the law. But that is not the same thing as impugning a man's integrity. In order to practice as a lawyer, what he needs is personal integrity. He needs to be an honest man. He needs to be a man that is worth entrusting with the honor of a lawyer. And this is not the same thing as a man who has been charged and convicted for pursuing his political convictions. Ramsbottom dismissed the attempt by the Law Society to have Mandela removed. I've been trying to research who Ramsbottom was and to understand how it came about that even within the context of apartheid, even within the apartheid judiciary, you could have a judge who is quite happy to be unpopular and not to be liked by his colleagues. I have not yet done that research, but I plan to in due course, promise you. So the first strike-off of 1954 failed. When he was in prison at Robben Island, Subsequent to his conviction for his participation in the acts of sabotage, there was another attempt to get him struck off the roll. And this is what I call the second strike off. And this is, I think, in 1968. But this again failed. So there were, in fact, 2 attempts to get Mandela struck off the roll of attorneys. And those attempts were driven by the Law Society. So that body that pretends to be interested in the discipline of lawyers was actually a political institution. All right. So we need to then just look at Mandela's practice, and let's look at specific cases to see what approach he followed. This is now the 4th aspect of Mandela the lawyer. So we see this a description given by Winnie Mandela, most of you are familiar with. Basically, it was impossible to get access to the firm because it was constantly overrun by clients. I mean, Oliver Tambo says, to reach our desks each morning, Nelson and I ran the gauntlet of patient queues of people overflowing from the chairs in the waiting room into the corridors. Winnie Mandela would later recall how she would have to wait to see him, shoulder to shoulder with clients, in the lobby area when she came to visit. Black clients came from all over the country to see Mandela in Tambo. They came from Natal, the Cape, the Free State, Northern Transvaal, Tambo recalled, and of course from Johannesburg and the areas next to Johannesburg. So this was, by all accounts, an extremely busy firm. But they made no money because most of the work that they did was the so-called pro deal. And what they did, they divided the firm, divided the firm into 3 areas: criminal, civil, and political. Who did the criminal? Mandela, of course. Who did the civil that required a little bit of thinking? Oliver Tambo. But they both appreciated the respective strengths of each other. There was no query about this. A civil case came, Mandela closed his eyes and says, OR, this is for you. A criminal case came, OR knew it went to Mandela. Political cases were usually split. The more complex they were, it would be shifted to Oliver Tambo. and then those that were likely to generate publicity and media attention, they went to Mandela. So you see, this was a partnership made in heaven. All right, so this is a recollection made by someone. These are notes I've been making when interviewing people. A recollection made by someone that Mandela and Tambo was a place where clients could find a sympathetic ear and a competent ally, a place where they would not be turned away or cheated, a place where they might actually feel proud to be represented by men of their own skin color. Mandela recalls here having gone to Mpumalanga, where he says in this village that he went to, it was literally the first time that those people had seen a black lawyer. They had heard about lawyers, but their imagination of what a lawyer looked like was nothing like Mandela. And when they saw him arrive, there was a sense of euphoria, a sense of jubilation that one of our own is also a lawyer, and one of our own will be speaking for us in court. In many respects, that world has not yet disappeared. People still find it strange that, there are some people who look like some people who are appearing in court. I'm waiting for my lawyer. And then you show up and you start taking notes. They say, but where's the lawyer coming? So, you will experience those things very soon, as soon as you start practicing, especially if you're a woman. They'll say, can you please make me tea? And then you're like, no, okay, sorry, I apologize, I didn't realize. But that kind of prejudice was prevalent in the 50s, but it is still prevalent in 2018. Okay, so this is a description of the kind of work that, this is from Oliver Tambo, who explains, just to give a context, It was a crime to walk through a whites-only door, a crime to ride a whites-only bus, a crime to use a whites-only drinking fountain, a crime to walk on a whites-only beach, a crime to be on the streets past 11, a crime not to have a passbook, blah, blah, a crime to be unemployed, a crime to be employed in the wrong place, a crime to live in certain places, and a crime to... All of these people accused of these crimes ultimately became clients of Mandela and Tambo. But what this meant, because of the totalizing nature of apartheid, it was truly totalizing. Blackness became a crime. The fact that you were black living in South Africa was de facto criminal. So because of this totalizing nature of apartheid, the firm of Mandela and Tambo could not afford to be the traditional attorney firm. It had to take a partisan stance. It had to side with the people or to perish. It ultimately decided that it would side with the people. But the paradox is that in siding with the people, the firm planted the seeds of its own destruction. So I wanted to say a few things about Mandela at court. We've already seen his appearance and his flamboyance. I do want to say a couple of things about the kind of cases that he would do. And so here I deal with what I call the struggle for visibility. It's just an example of what it must have been like to be Mandela and trying to put across a point in court. Mandela is representing a criminal accused, and his fellow is Elliot Setwaba. He stands up, records his appearance as an attorney. But before he can start talking, the magistrate says, "Are you entitled to appear in court?" He then says, "Well, I'm an admitted attorney." Then the magistrate says, "Well, I need proof that you're admitted. Where is your certificate?" And if you know anything about a court, no one ever asks you for a certificate. You stand up and you say, "Well, here I am. Don't you know about me?" But the magistrate then refused to carry on with the case and instructed him that he should bring his certificate. And look at the exchange, and this is all recorded in the law reports. Look at the exchange between Mandela and the magistrate. So Mandela is cross-examining a client, and the magistrate says, "I've warned you not to ask irrelevant questions. I won't have any nonsense from you. Proceed, ask your next question." And then Mandela tries to hesitate, and the magistrate shouts at him, "Ask your next question." And then Mandela says, "But I still have a question." He says, "I don't take instructions from you." And then again Mandela says, "But your worship is making it difficult for me to proceed." And then the magistrate says, "If you are going to take this attitude, I shall record every question and show how irrelevant your questions are." And then it continues in this vein until the magistrate says, "Hey you, I told you to sit down." And then Mandela is still hesitant, and then the magistrate instructs the court orderly, "Get this man to sit down." He eventually sits down. But then in the course of this, the magistrate says, "You've got a final warning. If you don't listen, I'm going to get you into trouble." And then eventually the witness is excused on the instruction of the magistrate. And then Mandela is told, this client of yours can either decide to be represented by you or find a different lawyer. And the client, of course, says, "I'd rather proceed with Mr. Mandela." And the magistrate says, no, go and get another attorney. So we see here the struggle for visibility in the sense that the professional qualifications alone were still not enough in a society that was racially totalizing. And Mandela needed to struggle to make himself visible. And this case, the Setwaba case, is an illustration of the kind of difficulty that he was experiencing because the attack had shifted from the system. The attack was now directly towards him and making it almost impossible for him to do his basic job as a lawyer. We take another example of Godfrey Pitje. And Pitje was Mandela's clerk. There was a law or a rule at the time which separated the sitting arrangements between white and black. You had to sit, if you were black, on the black side, if you were white, on the so-called European side. But Pitje goes to court. It's unclear on the cases whether he deliberately ignored the Europeans' only sign. But he went to court and he simply sat on the table that was marked for Europeans. That, of course, got the magistrate worked up. and asks him, go and sit where the natives must sit. And then Pitcher says, why? I'm a lawyer, I can sit anywhere. And then the judge says, but this is my court, and I'm not going to argue. And then Pitcher says, is that an order of court? And then the magistrate says, yes, it is an order of court. And then he says, well, I'm entitled to an explanation. And then he was fined £5 for contempt of court. This case, the Pitcher case, was taken on appeal before the appellate division. The appellate division actually found in favor of the magistrate and found that there was nothing wrong in giving that instruction, and upon non-compliance therewith, imposing a contempt of court and a summary trial there and then. And then take the third one, which was Douglas Lukele, because the consequences for Douglas Lukele were actually much more tragic than they had been for Godfrey Pitcher, because he had done the same thing, sitting on the wrong side of the table. But Douglas Lukele was from Swaziland, and as soon as he was convicted of contempt, he was ejected out of the country, back to Swaziland. Arrested, detained, and deported. I've tried to follow up on Douglas Lukele and to find out what happened to him after. I know with Godfrey Pitcher that Godfrey subsequently became an attorney. He started the Black Lawyers Association. Under him, the very first black woman qualified as an attorney in 1963. With Douglas Lukele left South Africa on this deportation order. He went to Swaziland, but his career seems to have received fertile ground in Swaziland, because no doubt he came with the stories of his deportation from South Africa. But when he was in Swaziland, he qualified as a lawyer, became a prosecutor, and I think in the 80s, he was serving as the Attorney General of that country. So this deportation seems to have actually had a different effect. All right. I have other cases for Mandela. I must talk about this one because it is an aspect that I found interesting in trying to research Mandela's approach to the law. Because here, as you can see, I am sort of critical of Mandela and the use of the legal tactics that would stretch bounds of ethical behavior. There is a story told by Dennis Goldberg, and it's reported by David Smith in the book Young Mandela, where Mandela is representing a black man accused of rape. And the accuser is a white woman. And Mandela actually sees this because, as you know, Mandela's flamboyance, he always thought that a court was a site of struggle. It was a platform to play out the absurdities of apartheid. When Mandela is cross-examining the white woman, he is acutely aware of the deeply embarrassing tale of penetration by black men. And he thinks he is going to touch upon this area because it is a particularly soft, quote-unquote, area. And look at the questions. And Mandela actually recounts the same story in his own book. The question, was there penetration? Did he remove your underwear? Did he actually put his, in your... At a certain point in time, it became intolerable for the white woman to answer the questions. I have further quotes here because at some point she said, I'm not answering questions from a K something. And the magistrate says, I'm sorry, ma'am, unless you are able to answer these questions, it's impossible for us to proceed. She says, well, I've told you I'm not answering questions from a, even if they are a lawyer, they are still a. Exactly. There's someone who said it, I didn't say it. The outcome of the trial was an acquittal. In other words, a win for Mandela's client. But it raises difficult questions about questions of gender and the intersection with race, right? Whether or not this is a case that could have been dealt with differently. and whether the fact of race and gender intertwining in Mandela, the black man, and the accuser, a white woman. But those are difficult ethical questions. And here I simply make the point that Mandela was not afraid to stretch the bounds of ethical behavior, if that would secure him a short-term victory. Another case that might appear controversial is Mandela's representation of a colored man before the classification board. Those of you who don't know what the classification board is, under apartheid, everyone had to belong to a race. Unlike these days where you can just choose, we're all African. Okay, maybe. Well, actually, Sobukwe did say that this thing of race doesn't exist. Everyone is an African. But under the apartheid, there was a classification board, and you had to belong to a race. And if there was a dispute about which race you belonged to, you went to this board, and this board looked at you and either put a pencil here or whatever. But there would be a way in which you would be classified. Mandela once appeared before the classification board on behalf of a client. And the question here was, if you classify as colored, right, you then go up in the social and economic scale. You classify as native, you go down. So you have a native fellow. How does he want to classify? Obviously colored. You have a colored fellow. How does he want to classify? Obviously white. They go to this guy, and this is how Mandela describes this. Instead, he says, this is the magistrate. The magistrate seemed uninterested in both my evidence and the prosecutor's demurrer. Instead, now the magistrate is making the classification. He stared at my client and gruffly asked him to turn around so that his back faced the bench. After scrutinizing my client's shoulders, which sloped down sharply, he nodded to the other officials and upheld the appeal. In the view of the white authorities those days, sloping shoulders were one stereotype of the colored physique, like that. So Mandela wins the case. In other words, exploiting the absurdities of the legal system for the benefit of a client, right? So it looks like as a lawyer, not everything must be done according to the book, and not everything is black or white. And so it came about that the course of this man's life was decided purely on the magistrate's opinion about the structure of his shoulders. The case does illustrate something deeper about the apartheid system, and perhaps something deeper even about racial stereotypes for those of among us who still hold racial stereotypes. That they are absurd. They make no sense. They are based on complete and utter fabrications. Perceptions that cannot be founded in law, perceptions that cannot be founded in fact, and perceptions that have no scientific basis. But it also shows another thing. The trajectory of a man's life under apartheid could be decided by quote-unquote law, hence putting the courts at the center of the application of the apartheid system, and putting then the role of lawyers to the forefront of the system. Okay, so later on he obviously claimed that he didn't support the Population Registration Act, but he was quite happy to use it to win a case. So I've drawn out at least 5 cases to try and illustrate larger points about what Mandela was like as a lawyer. Later on, and this is now after 1956, and we know what happened in 1956 is that Mandela was charged for his participation in the Freedom Charter. And this is the so-called Treason Trial. And this is an article published by the Sunday Times about the trial being moved. What then happened is that he was ultimately found guilty and sentenced to 5 years. At this point in time, Mandela's activities as a lawyer, and especially his choices to use law to pursue a political cause, had now cost him his professionally chosen life. From 1956, Mandela, in a sense, recedes from practice because he is in prison, but also he is attending another criminal trial. And this is the third trial after the so-called acts of sabotage. What we know in 1960, you know the date, Dingan's Day, what's this, 19th of December. Why that is important is that after 9 years of Mandela's practice as a lawyer, in other words, 9 years of thinking the system could be shaken from within, in 1960, it struck Mandela that this was no longer possible. The one particular event that was the turning point was the 21st of March, 1960, Sharpeville. After that period, when 69 people were killed for participation in the Anti-Pass campaign, Mandela began to investigate the possibility of change within the legal system. And his language shifts, and he begins to think more about justice and the morality of the system. In 1960, in December, Mandela announced to his colleagues that they would now form Umkhonto weSizwe, and Mandela would become the first commander-in-chief of Umkhonto weSizwe. At this point in time, it is unmistakable in my research that Mandela had given up on the possibility of change through legal means. And what he actually thought was now possible was revolution. But even within the context of revolution, Mandela still thought that a form of terrorism where there would be indiscriminate killing would be unacceptable. And hence, they started thinking about targeted acts of sabotage. That very same year, Oliver Tambo went underground. Subsequent to having gone underground, he left for exile. The firm that the Law Society had twice tried to shut down, it was now in the hands of the Law Society to do with it as they pleased. Promptly, they appointed an administrator. They closed the firm down, they distributed the files, and they shut the offices. 10 years after the most promising law firm had begun, its doors were closed because of politics, in circumstances where the partners believed that politics were the only answer to South Africa's crisis of representation. Mandela's final act, this is now the third section of my talk. Mandela's final act in court is a speech that he gave in 1962. It's been transcribed variously as Black Man in a White Man's Court. It consolidates Mandela's view about the legal system and the courts after 10 years of trial and error. Here, Mandela had fired his lawyers, most of whom were white, and he had asked that he would represent himself. And the first thing he did was to ask for the recusal of the magistrate. But look at the reasons he gives for asking for the recusal. I want to apply for your worship's recusal from this case. I challenge the right of this court to hear the case on two grounds. First, I challenge it because I fear that I will not be given a fair and proper trial. Secondly, I consider myself neither legally nor morally bound to obey laws made by a parliament in which I have no representation. He had now turned the system upside down, turned it on its head. He knew that the system was not designed by him, not for his people. And that the only way that a black man could exist in a court was by changing the court itself. He was no longer willing to be a participant in an act of legitimation, but what he wanted to do was to change the system. He continues, in a political trial such as this one, which involves a clash of the aspirations of the African people and those of whites, the country's courts, as presently constituted, cannot be impartial and fair. In such cases, whites are interested parties. To have a white judicial officer presiding, however high his esteem and however strong his sense of fairness and justice, is to make white judges in their own case. This is probably the most powerful statement that Mandela ever made as a lawyer, because for the first time, Mandela recognized the ultimate political construct of the judicial system. He ultimately recognized that in order for the judicial system to function properly, it must function according to the laws of justice. But it could not function according to the laws of justice unless it is appended from within. But this, again, does not provide a complete answer, because it remains a paradoxical question to answer how it came about that Mandela was still willing to subject himself to a court that he believed could not possibly deliver justice to him. But it looks like that paradox can be resolved by Mandela's understanding of the distinction between the officers occupying the institution and the institution itself. Because what he complains of is a white judicial officer presiding, who he doubts would have a sense of fairness and justice. So perhaps Mandela at this point has still not given up on the law itself. He has given up on the people responsible for the implementation of the law. Look at what he says. It is true that an African who is charged in a court of law enjoys, on the surface, the same rights and privileges as an accused who is white, and so far as the conduct of this trial is concerned. He is governed by the same rules of procedure and evidence as applied to a white accused. But it would be grossly inaccurate to conclude from this fact that an African consequently enjoys equality before the law. In other words, these courts presided by biased people are just a facade. They are hiding the iron fist underneath the velvet glove. 2 years earlier, in 1960, there was another speech from the dock. We have forgotten about this speech. It was not given by Mandela. It was given by another son of the soil, Robert Sobukwe. April 1960. The date of the trial is the 6th of April 1960. This is how his speech ran. It will be remembered that when this case began, we refused to plead because we felt no moral obligation whatsoever to obey laws which are made by whites and are administered by whites from an unjust law cannot be applied justly. We believe in one race only, the human race, to which all belong. The history of the human race is a long history of struggle against all restrictions, physical, mental, and spiritual. And we would have betrayed the human race if we had not done our share. I want to stop here on the note by Sobukwe and to suggest to us, we have gone through now the 10 years of Mandela the lawyer. We have gone through his attempts at restructuring the system from within. But we have seen what ultimately happened in 1962 when he gives up on the lawyers, the judicial officers, the prosecutors, and the magistrate. But I want to say we see through that even in the era of 1962, even in the era of the aggressive racializing state, the faith in the law itself remained. And if we take seriously Sobukwe's belief that what is the issue is that an unjust law cannot be applied justly, the belief in justice itself remains. But the belief in justice is only possible in a society that is founded on justice. And perhaps the greatest lesson we take from Mandela the lawyer is this abiding belief in the justice of the system. Thank you. So can I? Sorry, I'm trying to close this. Okay, brilliant.
Wow, Prof. I think the work that you're doing is so important to be captured for the history of the future generations. And I'm hoping that there will be more than one sequel to The Land is Ours, because I think it's very important that aspiring lawyers and also the general public understand the real history of South Africa. So, Prof. Ngcukaitobi, I'm going to get it right. Thank you very much. I will take the time now to ask Mr. Pedro Mzeleni to please do the vote of thanks and the closure of the function. Thank you. Pedro.
Yeah. Thank you so much, Program Director. My job is very simple, is to say thank you to all of you, and we go home. But firstly, on behalf of the Faculty of Law, the Chair for Critical Studies in Higher Education Transformation, which stands for CriSHET, and also the Herald newspaper, for the wonderful build-up in the media this week. Thank you to all those partners for pulling everything together this afternoon. I must also thank the students, the LLB class, for honoring the event. I think the message is clear that the practice of your profession goes beyond the classroom. It entails what society also has to offer in terms of the pressing issues that are contextual to your profession that you should also pay attention to, especially as far as politics is concerned. I took it very seriously that Madiba took 46 years to get a degree. So it means we're still fine. We're still fine. I still have a long time to get my degree. Obviously, colleagues, as you would know, pulling an event like this doesn't happen overnight. There are people who spend sleepless nights to put it all together. So the background team that made sure the hospitality of the advocate in PE, who made it possible, Omarisa, Otanya, Deronique, Uvuyo, Zandile, Prof. Chivas, and also the Dean of Law, Professor Gavanji, and also the Chair of CriSHET, Professor Andre Kitt, and obviously from the Herald, I can only thank the editor, the new editor, Usis Nwabisa, Makunga. So thank you very much to those stakeholders and those colleagues for pulling everything together. Even today, the logistics team of the venue, the cameraman, the media, people who made sure that above the belt, we are taken care of, catering. Sabulela matot. Let me now go to the speaker, Professor Ngcukaitobi. You are a professor now. You know, my leader, as I was sitting there listening to you, I realized that the more I know, the more I realize that I don't know. So it's a challenge to me that I must do what Lenin said, which is to learn, and learn. And most importantly, to unlearn. So you have actually challenged me as a student to go out there and find out more about the Republic of South Africa that I am living in. What is it that happened and what has shaped the complexities that we have in our society, and also its entanglements and how its future would look like that I am going to inherit as a young person. So thank you so much for that. I call it Gear 5 of intellectual stimulation. The level of the critique moved from Gear 3 to Gear 5. So you have challenged my thinking a lot later. You were hitting the roof. So thank you so much for such great words. It was very, very informative. Colleagues, it's now clear that there is a lot that needs to be learned about this figure of Madiba. Maybe I should come also and deliver Mandela as a boxer. Just to, entangle this particular figure. Colleagues, all in all, man, thank you so much for gathering this event today. We wish the students all the best in your examinations. We wish you all the best of luck in all your endeavors. And have a great evening, everyone. Thank you so much.